The final rule emphasizes that Congress clearly intended the ADA Amendments Act to expand coverage. Quote, "It is our expectation that because this bill makes the definition of disability more generous, some people who were not covered before will now be covered." End of quote. When considering requests for modifications, accommodations, or auxiliary services or aids, the entity should give considerable weight to documentation of past modifications, accommodations, or auxiliary aids or services received in similar testing situations, or provided in response to an individual education program, provided under the IDEA, or a plan describing services provided under Section 504 of the Rehabilitation Act of 1973, often referred to as a Section 504 plan. The ADA, as amended, expressly prohibits any consideration of the ameliorative effects of mitigating measures when determining whether an individual's impairment substantially limits a major life activity. Importantly, an example in the final rule illustrating dyslexia shows a discrepancy between the person's age, measured intelligence, and education, and that person's actual versus expected achievement. One of the most important elements in the final rule is the concept of condition, manner, or duration. These terms are critical in interpretation of the rules of construction for substantially limited. Specifically, it is made clear that it could be useful to consider, in comparison to most people in the general population, the conditions under which an individual performs a major life activity, the manner in which an individual performs a major life activity, or the time it takes, duration, an individual to perform a major life activity. These three critical factors, condition, manner, and duration, provide significant support to bright dyslexics requesting accommodations. Giving deference to how a person reads is a major leap forward. The score a dyslexic attains on a test does not reveal the extraordinary effort she must put forth to obtain that score, much more than most people who obtain the same score. The final rule notes that the language regarding the difficulty, effort, or time required to perform a major life activity should prove extremely helpful to dyslexic individuals asserting a need for testing accommodations. An individual with dyslexia may need to approach reading or writing in a distinct manner or under different conditions than most people in the general population, possibly employing aids including verbalizing, visualizing, decoding, or phonology, such that the effort required could support a determination that the individual is substantially limited in the major life activity of reading or writing. In passing the ADA Amendments Act, Congress clarified that courts had misinterpreted the ADA definition of disability by, among other things, inappropriately emphasizing the capabilities of people with disabilities to achieve certain outcomes. For example, someone with dyslexia may achieve a high level of academic success, but may nevertheless be substantially limited in one or more of the major life activities of reading, writing, speaking, or learning because of the additional time or effort he must spend to read, speak, write, or learn compared to most people in the general population. The final rule notes that some courts have found that students who have reached a high level of academic achievement are not to be considered individuals with disabilities under the ADA, as such individuals may have difficulty demonstrating substantial limitation in the major life activities of learning or reading relative to most people. The final rule does not support such a view. It states, when considering the condition, manner, or duration in which an individual with dyslexia performs a major life activity, it is critical to reject the assumption that an individual who performs well academically or otherwise cannot be substantially limited in activities such as learning, reading, writing, thinking, or speaking. The final rule quotes Congress that the comparison of individuals with dyslexia to most people requires a careful analysis of the method and manner in which an individual's impairment limits a major life activity. For the majority of the population, the basic mechanics of reading and writing do not pose extraordinary lifelong challenges. Rather, recognizing and forming letters and words are effortless, unconscious, automatic processes. The process of reading for an individual with dyslexia is word by word and otherwise cumbersome, painful, deliberate, and slow throughout life. The final rule reflects congressional intent and makes clear that the outcome an individual with a disability is able to achieve is not determinative of whether an individual is substantially limited in a major life activity. Instead, an individual can demonstrate the extent to which an impairment affects the condition, manner, or duration in which he performs a major life activity, such that it constitutes a substantial limitation. The ultimate outcome of an individual's efforts should not undermine a claim of disability, even if that individual ultimately is able to achieve the same or similar result as someone without the impairment. The final rule emphasizes that the testing results or grades of an individual seeking reasonable modifications or testing accommodations may not be relevant to determinations of disability, in contrast to what testing agencies often claim.